This petition was filed before the dismissal.
Mr. Mangukia, please don't act so casual. Please don't act so casual.
I'm
There
not-
is something very serious about. I am proposing to initiate contempt proceedings against your client. It's not something which you should be happy about. And as far as I am
My
concerned, Mr. Mangukia, the system of this court, the computerized system of this court has been appreciated even by the Honorable Supreme Court in the last judgment. If whenever there is a matter which is disposed of and an order is uploaded, immediate notification is received by the advocate on his mobile that yes, this matter is disposed of. So how can you claim that ignorance, that I did not know about the matter being disposed of? How can you as an advocate say that I did not know about this? I will check up the records and I will, if you want to dispute it, I will find out the date and the time when the SMS was sent to you.
I never see it.
That is not my concern, Mr. Mangukia. You cannot be so casual about it. This is something very, very serious.
I'm sorry.
Yes, you are absolutely casual about it.
I'm not casual.
Yes.
Please now give me 1 minute.
Yes.
This is not an
Please
give me 1 minute.
When the High Court disposes of a writ petition and basis which this writ petition has become infructuous, that matter is not brought to the notice of this court, and this court ensures that this court has
question to myself.
Yes.
This is not within my exclusive knowledge.
Why not?
I did not. Let me.
Yes.
Allow me to.
Yes. Yes.
Without any emotions.
Yes. Yes. That is not for you, for Mr. Mangukia. When there is an issue of suppression, when there is an issue,
I will say to this honorable court, suppression would be a fact which is exclusive knowledge of a person.
Yes.
This is in domain of the government people also.
That's all right. That's all right. You have filed.
I am responsible. They are also
you have filed the petition, Mr. Mangukia. Is it
but
not?
Everybody has to.
That is all right. The primary responsibility is upon you.
Lord,
there may be some responsibility.
I'm sorry, Lord.
Yes.
With great respect.
Very well, Mr. Mangukia. Is that your submission? Then I'll record it and I'll deal with it.
My lord said email is also received by the advocate.
Yes, he doesn't see it.
We have also practiced. Even I get emails today.
Right.
Matters where there is vakalatnama. So does Ms. Prajapati. So does Mr. Mangukia.
You don't see it.
And please see page B of this affidavit. How can this deponent petitioner say such obnoxious things on affidavit? Page B, the fifth line onwards.
Yes.
When my matter was disposed of by the honorable court, the division bench of our honorable court has recorded in 2 paragraphs that there are repeated leave notes and sick notes of Mr. Mangukia before the honorable division bench.
Paragraph number?
Page B, paragraph number, the 5th line onwards, lordships.
But that's not the.
And I read that. I read
dismissal.
I read 1 minute now, Mr. Mangukia.
Yes, 1 second, Mr. Mangukia. Yes.
I read that in context of the Honorable Division Bench order. The order sheet further indicates that repeated sick notes and leave notes have been circulated by the 2 learned advocates appearing for the petitioner, and the matter was got adjourned. This is clearly observed by the Honorable Division Bench. In that context, how could such a callous statement be made by an order of the Honorable Division Bench? And then Mr. Mangukia says he is not aware. All lawyers in this court get emails. As soon as, even if the matter is adjourned, we get emails.
Yes, Mr. Mangukia. Yes.
First of all, there is no intention to do anything. And client was not aware of the listing of this matter on the day on which this matter was listed. And it was not our contention before this honorable court that this honorable court taken an action. That
is between me and the collector. I never invited you to make any submissions. Yes.
That has happened because of not mine.
That is because the full facts were not placed before me. On that date, upon the division bench, decision of the division bench, does this petition, Mr. Mangukia, does this writ petition not become infructuous upon the decision of the division bench? Why?
Because the contempt was committed at the time when the order was recorded.
Right. So then I'm not taking up contempt, and that your statement is self-contradictory. When you say that you have not invited this court or you have not asked this court to take any action, it was taken upon by me,
Lordship.
right? But then at the same
But
time,
then how do I be made a responsible
why?
for that, Lord?
Because you are not making you responsible for that action. I am asking that on the date when this court had passed this order, it was very clear that there did not remain any cause of action. Your cause of action was over.
Intention is to be
Mr. Mangukia, Mr. Mangukia, you are a senior member of the bar, but please appreciate that there is a limit to everything. We have stretched ourselves in accommodating you and your office. We have stretched ourselves. Please don't take the leeway given by this court as a license. I hope you get my message very clearly.
I will not utter a word until my Lord says so.
What kind of practice is this, Mr. Mangukia? What kind of practice is this? Yes, what do you want to say?
There is no intention to mislead this honorable court. One.
I do not have the clairvoyant powers, Mr. Mangukia, to look into people's hearts.
I'm not
Yes.
arguing the matter. I'm
Yes.
not defending, either
Yes.
I'm arguing matter.
Yes,
Lord, it's a mistake. It can be attributed to me alone also. No difficulty. My client was not aware that this matter was listed on this day. Either we did not inform it or he did not find it out. Lord, on that day, the honorable court was not got very well with the collector because day one, the notice was issued and this honorable court orally instructed to ask the collector to explain. But there are no explanations or forthcoming, despite 3 adjournments. Therefore, this court was inclined to issue the notice. Lord, this notice, my petitions has been dismissed. Let me now inform the honorable court on the ground that I did not file amended memo of the petition. This is factually.
I am not sitting in
My
appeal,
learned friend is
review.
reading.
I am not in appeal, review or anything. That's a decision of the division bench. I am bound by it.
Therefore,
Plain and simple.
Therefore, I was not making any statement except
Yes.
that my petition has been
Yes.
disposed of ex parte. And it is a fact.
So, Mr. Mangukia, do I take it that you are shouldering the responsibility?
I'll shoulder it, no problem.
No, don't put it on me.
I'll
Either
shoulder it.
then let me have your affidavit. Let me have your affidavit on record. Either it is that petitioner or you. Let me have your affidavit on record. What do you say about it? This will not go unnoticed. I have the highest respect for learned advocates, but then learned advocates also should behave as officers of the court.
We started with the tendering unconditioned apology.
No. The initiation is by trying to justify.
No, I'm not
Yes.
justifying.
Yes. Let me have your affidavit, Mr. Mangukia.
If my Lord, I'll do it.
Yes, please. Please do it. Let me have your affidavit. If you are saying that you are shouldering the responsibility, I will have your affidavit. Let me see. Yes.
I will not satisfy my client for no fault of his.
Very well. That is how it has to be. That is how it has to be. Yes.
To save my skin.
That is how, Mr. Mangukia, it has to be. That is how persons of principles are expected to behave. Expected to shoulder the responsibility, not to pass on the buck. If you have that courage, take it. We will see. Yes. Yes.